It's my pleasure to welcome you to the second day of the CIS Arbitration Conference, titled CIS-related Disputes, Treaties, Sanctions, and Compliance. My name is Yari Krivoy. I am one of co-editors of CIS Arbitration Forum, and I'm also Senior Fellow at the British Institute of International Comparative Law. Welcome to those who are joining us who were here yesterday, and welcome to those who are joining us for the first time today. I would like to thank our sponsors, Kerry Olsen, for supporting this event. We will have a keynote address followed by two panels, one panel on enforcement and another panel dealing with sanctions. We are going to record this event, and we may publish fragments of the recording of the event later, but the presentations rather than the Q&A session. If possible, I would like to ask you to rename yourself so that it's clear what your name is and your affiliation in brackets. That will make it easier for us to run the Q&A session. After each panel, and hopefully after the keynote address, we'll have a short Q&A session. So with that, let me pass the virtual microphone to Dmitry Davydenko, who is going to introduce our keynote speaker, Ekaterina Kudelich. Dmitry, over to you.
Hello, everyone. My name is Dmitry Davydenko. I am Director of CIS Arbitration Forum and Associate Professor at Mo University and High School of Economics. And I am very glad to introduce Ekaterina Kudelich, who is the Acting Director of International Law and Cooperation Department in the Ministry of Justice of the Russian Federation. She has studied various aspects of public and private international law, legal assistance in civil and criminal matters, representations of the Russian Federation in international foreign courts and international arbitrations, and in particular in Court of Eurasian Economic Union. The subject of our speech will be today, first of all, recognition and enforcement of foreign judgments, and the keynote about new Russian developments is to Ekaterina Kudelich. So, Ekaterina, the floor is yours.
Yes, good morning, dear colleagues. I hope you can hear me. Yes?
Yes, quite fine, yes.
Okay, thank you. It's a great honor and pleasure for me to appear before professionals in international litigation field. On April 8th this year, President Putin signed a decree authorizing the Russian Ministry of Justice to sign the Hague Convention on the recognition and enforcement of foreign judgments in civil and commercial matters. Certainly, signing does not mean that the Russian government will be willing to ratify this convention in the future, but still it means that legal concepts realized in the convention are shared by the Russian Federation, and certainly it's a good sign. Also, we've got information from the Permanent Bureau, the Hague Conference on the Private International Law, that many states and international delegations which have actively participated in drafting of the text of the convention for more than 10 years are now working on the accession to it. And we are primarily talking about the European Union, Brazil, China, and South Korea. That is why at this point, any assessment of the success or failure of this convention is somewhat fortune-telling. However, I'm sure that positive attitude of lawyers to it and their certainty in practical bonuses of the convention will positively influence or even persuade the governments in the necessity of having such a legal instrument on the global level. Bearing this goal in mind, I decided to present you my personal brief overview of the mechanisms set forth in the convention from the perspective of both its advantages for business and ordinary people, and simultaneously from the point of a risk management approach for governments, many of which are concerned about the potential negative consequences of the convention's entry into force. For the last several decades, the world is facing a steady increase in the total amount of cases on recognition and enforcement of foreign judgments and arbitral awards. And this means that substantial part of judicial proceedings transforms from exclusively national into transnational, with all emanating consequences. And first of all, I mean the need to provide private persons with adequate procedural mechanisms of recognition and enforcement of judgments, not only within the territory of the state issuing these judgments, but also in those countries where a debtor's assets are placed. I think that we all understand that today's business and everyday life of ordinary people obviously need a predictable and liberal regime of transnational enforcement of judges. It has been long considered that the regulatory potential of the New York Convention was more than enough for effective protection of rights of the parties to the relations with the so-called foreign element. But modern trends show that international arbitration suits mostly the needs of large companies, while small and medium businesses, and more importantly, natural persons actively entering into multi-jurisdictional relations continue to rely on state court machinery. And that's why I think we shall applaud the Hague Conference on Private International Law, which succeeded in finalizing the Universal Convention in the field of transnational circulation of judgments and avoiding serious obstacles and restrictions existing in this area. If I asked you what is the main fundamental obstacle to predictable and simplified procedure of granting exequatur, I'm sure you would say that this is the lack of trust between judicial systems at the global level. It is the common point, and we still, but still we used to think this way. Frankly speaking, I find this thesis to be a stereotype. Before Ministry of Justice for more than 11 years, I worked in the Supreme Commercial Court of the Russian Federation, which was liquidated in 2014. And I was dealing with international litigation. And as we could not seriously influence the drafting and signing of the conventions containing the rules on the enforcement of foreign judgments, we tried to persuade judges to rely on principle of comity and reciprocity in cases when there was no such convention. And you know, Russian judges still follow this approach. And in 2020, foreign judgments coming from Austria, Belgium, Netherlands, and United Kingdom were granted exequatur without having international convention. And you know, it makes me happy because honestly speaking, I could never find any serious support to the thesis about distrust or even hostility of courts to the judgments of their foreign colleagues. I think that some reasons for such distrust may emerge, but only in high-profile cases involving, we all know this, not only law, but also big politics. And of course, we know the examples of such cases. But even in such instances, each state has in its toolbox a public policy clause enabling states to resist foreign judgments, which they consider as undermining their legal order. But the majority of cases reveals neither reasons for doubts in impartiality of the court and fairness of the trials, nor serious obstacles to conferring cross-border effect on judgments. Therefore, although each state has a preferred ideology in the field of granting exequatur to foreign judgments, and this may be either the liberal fidelity to international comity or more stringent adherence to the frames of the relevant international treaties. But in any case, in my opinion, these concepts relate more to external policy than to law. Meanwhile, the entirely protectionist defensive objectives may be transmitted to exclusively legal plane and maintained by practical mechanisms known as grounds for refusal of recognition and enforcement of foreign judgments. And each of these grounds serves both to protect the right to fair trial and more globally to protect public order. And exactly with this positive, optimistic view, I would like to consider some key mechanisms and concepts of the Hague Convention. First and foremost, it is worth noting that the Convention provides no rule on direct international jurisdiction. This issue is currently considered by the expert group of the Hague Conference on Private International Law, and the heated debates demonstrate dim prospects for a mutually acceptable compromise. But still, as a member of this group, I do hope that a good compromise on some jurisdictional aspects of international litigation can be found. Regarding the scope of application, the Judgments Convention mechanism is based on a broad list of exceptions to the civil and commercial matters benefiting from the conventional regime of recognition and enforcement of judgments. There are several reasons for such exclusions. Firstly, there are already in place specialized convention regimes like those for maintenance and other family matters. Secondly, states are reluctant to elevate the grant of exequatur of judgments on certain very sensitive issues to universal international level. Such sensitive issues in particular cover activities of armed forces, law enforcement bodies in the exercise of their duties, defamation, unilateral restructuring of sovereign debt, and some others. Such exceptions, despite their restricting impact on the regulatory framework of the convention, of course, they increase the chances of its success by excluding from its regime the most controversial questions. I need to emphasize that the convention provides a direct rule that judgment is not excluded from its scope by the mere fact that a state government, a governmental agency, or any other person acting for a state was a party to the proceedings. In turn, Article 19 of the convention entitles states to make a reservation that the convention is inapplicable to judgments arising from proceedings to which that state, a governmental agency, or any person acting for that state is a party. But nevertheless, the convention requires such declaration to be no broader than necessary. Moreover, a state making such a declaration becomes unable to extend the benefits of the conventional regime to judgments arising out of the proceedings initiated by that state itself and its organs or agencies. Yet the need for enforcement of such judgments is exceptionally high in the modern context. For example, Russian law enforcement agencies always, in many cases, need a legal conventional mechanism which would enable them to enforce, for example, civil judgments of Russian courts awarding damages caused by crime. That's why we can acknowledge that the provision of the convention in this respect are consistent and fair even on such specific issues. And the design of the convention is quite traditional. It stipulates a general rule on recognition and enforcement of judgments issued in the other member states that are final and entered into force. And this rule is supplemented by the guarantees of non-interference of foreign courts into the competence of the court's rendered judgment. These guarantees include the prohibition to review the merits of the judgments subject to recognition and enforcement, and requirement to assess such judgment in substance only to the extent necessary for the purposes of the convention. The convention governs both the grounds for recognition and enforcement and the basis for refusal in it. The convention in cases on rights in rem in immovable property safeguards the exclusive jurisdiction of the courts of the state where such property is situated. And Article 6 directly stipulates that judgment issued on rights in rem in immovable property shall be recognized and enforced if and only if the property is situated in the state of origin. In this regard, the rules on exclusive jurisdiction found in the convention reduce the risk of controversies arising from parallel judicial proceedings. A cornerstone of the whole architecture of the convention is the concept of indirect jurisdiction, which is not yet well developed in some countries, including Russia. Article 5 of the convention provides criteria of jurisdiction which need to be satisfied by the court of origin to secure the exequatur on the territory of the other party to the convention. The list of such criteria is broad and thoroughly regulated, but I will put aside the details. Judgments relying on a broader national, but I need to mention that if a judgment relying on broader national rules of direct international jurisdiction does not satisfy these jurisdictional filters containing in the convention, then such a judgment shall not be recognized and enforced under the convention. However, it doesn't mean that this judgment cannot be recognized and enforced. It can, but only on the basis of a bilateral treaty, if such a treaty exists. The mechanism establishing indirect jurisdiction provide substantial advantages for parties in terms of predictability, because at the stage of applying for enforcement, the applicant may assess compliance with conventional criteria of indirect jurisdiction, and then he can estimate the enforceability of the judgment. But there are also certain disadvantages. Obviously, the world encompasses a substantial amount of national legal system which have highly broad rules on direct international jurisdiction. And when conventional rules of indirect jurisdiction limit such framework, the phenomenon of the so-called jurisdictional gap emerges. In this sense, the convention was forced to leave certain issues unsolved. But we understand that this is obvious and imminent evil. I would like also say some words about the grounds for refusal of recognition and enforcement of judgments under the convention. Most of them, such as anti-notification of the defendant, violation of public order, rules related to the parallel proceedings, have already been implemented both in the treaty practice and in national legislations. In other words, in this part of the convention, the convention reflects the consensus of states. The convention provides, we can say that convention provides so far the most complete and unified regime of recognition and enforcement of foreign judgments informed by current tendencies and problems in this field. Judgment Convention has become the first Hague Convention supporting multilateralism directly through stipulating in the preamble the aim of facilitation, multilateral trade and investment. One of the novelties of the convention is the right of the member state subject to exclusive jurisdiction to recognize and enforce foreign judgments based on its national legislation, where such judgment cannot be enforced under the convention. It is the so-called favor recognition principle. This approach prevents controversies between the obligation of the member states under the present convention, while leaving open the cooperation on recognition and enforcement of foreign judgments on more favorable terms. Therefore, the convention precisely fixes the minimum standard of recognition and enforcement of foreign judgments. Despite the mentioned advantages, it is worth noting that the practical benefits of a universal mechanism on the basis of the convention will become visible only if most states accede to the convention. Otherwise, the very concept of unilateral regime of recognition and enforcement of foreign judgments will remain ink on paper. The main risks related to the implementation of the convention should also be borne in mind. I will mention some related to the Russian legal system and judiciary. Article 5 of the convention, as I said earlier, provides grounds for indirect jurisdiction of foreign courts. Since this concept is not present in the Russian legal system, I think that some risks emerge. First, there is a risk of controversy between the grounds of indirect jurisdiction provided under Article 5 of the convention and the Russian legislation on the exclusive jurisdiction of the courts requested to recognize and enforce foreign judgment. Secondly, abuse of these provisions may lead to attempts to review the merits of the judgments submitted to recognition and enforcement in other member states. At the same time, such risks are balanced by the direct prohibition of such review. Moreover, such provision enables the requested courts to ensure that there is no violation of public order, state sovereignty, and state security. One problematic issue under the convention is the remaining right of each state to unilaterally declare the convention inapplicable in relation to a particular member state. This mechanism was a compromised solution between the establishment of the regime of recognition and enforcement of foreign judgments and avoiding the obligation of states to enforce biased and defective judgments. However, the risk of ineffective application of the convention is pertaining to this provision, in particular in case of abuse. It shall be mentioned that the scope of the convention is substantially restricted in comparison to the scope of civil and commercial matters usually covered by other bilateral and multilateral international treaties on recognition and enforcement of foreign judgments or mutual legal assistance on civil matters. But in addition to matters directly excluded from the scope of the convention, it is in fact inapplicable to judgments issued when the arbitration clause was found null or inapplicable. And this exception stems from the fact that the proceedings relating to the arbitration fall outside the scope of the convention. Further, the convention does not cover the cases where the jurisdiction of the court is based on an exclusive choice of court agreement. These limitations also, I think, exclude substantial volume of transnational litigation from the scope of the convention. On the one hand, this limitation may be considered as a certain compromise to encourage the state to accede to the convention by safeguarding their broad enough powers that ensure their national priorities in course of recognition and enforcement of foreign judgment. But on the other hand, however, when applying these limitations, we need to take into account that there is a risk of legal uncertainty, while initially the convention mechanism is designed to enhance stable, predictable, unified regulation and enforcement of foreign judgment. In this regard, great importance should be given to the principle of good faith in the performance of the obligation under the convention by every member state. To summarize, I would like to mention that I consider prospects of the convention with great hope and optimism. This attitude is largely due to the fact that this convention strikes an optimal and very fragile balance between the free circulation of judgments, which would secure effective implementation of the right to fair trial, and consequently unity of judicial proceedings for a party and guarantee of national sovereignty and public interests of state. Unfortunately, in more modern circumstances, this aspect still remains important and relevant. Nonetheless, the convention may as well become an important impetus for states to comply with international standards of litigation so that their courts would not be running idle, but rather receive support from foreign courts for granting exequatur instead. In any case, I'm sure that the future lies in progress rather than adherence to obsolete rigid concept of closed systems of recognition and enforcement of foreign judgments. Thank you.
Thank you very much, Ekaterina, for your detailed report and your thoughts. We have very few minutes, as you informed me, but still a few questions. Would anyone like to ask a question to?
Yeah, if possible, I'd like to have to ask Ekaterina about this convention. Do I understand right that the enforcement of the foreign judgments under this convention is not automatic? For example, under the Article 10, as I see, recognition or enforcement of a judgment may be refused if the judgment awards damages that do not compensate a party for actual loss or harm suffered. As I understand, there is an opportunity for the other party to trial the case again in substance, merits. So it does not enforce the foreign judgment automatically, right?
I think the answer to this question will depend on the practice of the state which will apply this provision. But as I said earlier, there is a prohibition to review the judgment on the merits. But still some possibilities to limit the amount of compensation or amount of award rewarded by the judgment, but I think it still exists.
Yes, likewise, as in Article 7, they say that recognition or enforcement may be refused if the judgment was obtained by fraud. So actually, the other party may invoke this article and just to slow down the entire enforcement process, right? Just to claim that the judgment was obtained by fraud. And that it may take up to 1 year just to provide all the proof. So it means that actually the enforcement is not automatic. So there are some articles that allow the other party to stop the enforcement, right? So,
yes, the enforcement is not automatic, but I think that the mechanisms provided by the convention, they are similar to those already existing in the legal systems of the state. I think such kind of provisions, they exist in the procedural legislation of the majority of states, and the grounds for refusal are the same. So because if the judgment is what was rendered under any
with any violations.
with any violations, with any serious violations, which can be deemed as violation of the principle of fair trial, then the judgment can be set aside.
Mm-hmm. So and so we have this convention for all the judgments on civil matters, while as for the awards, we stay with the New York Convention of 1958, right? So
yes, right.
They do not overlap.
No, they do not overlap. This convention deals only with the judgments of the state courts, not the international arbitration awards.
Okay, thank you very much. I have no more questions.
If I see the timing, as you informed me, Ekaterina, that unfortunately you need to leave.
Yes, 1 minute left.
Okay. What do you think about the perspectives of Russia, accession of Russia to the Singapore Convention on Settlement Agreements resulting from mediation?
My answer will be short. It is not, as far as I know, it is not in the list of high priorities for Russia at this time. Though, and we do not have plans to sign this convention in the nearest future.
Okay, and is the question of transnational circulation of notarized documents in question to ensure that notarized documents are enforced internationally, such as settlement agreements or any other notarized acts?
We look very positively in this respect, and we would like to have such kind of treaties allowing the circulation of such kind of documents containing notarial deeds or authorized by notarial deeds. But these provisions shall contain in the bilateral treaties on international legal assistance on civil matters. And frankly speaking, the drafting and negotiating, yes, of these treaties is a very difficult task. And at this time, Russian Ministry of Justice, we are drafting the model bilateral treaty on legal assistance in civil matters, and this model treaty contains this provision, but still it will be subject to negotiations between the parties.
Thank you very much for your encouraging speech. That indeed we have now reason to believe that our international legal cooperation will be even better. Thank you very much.
Thank you.
Yeah, thank you very much, Ekaterina, for finding time in your busy schedule to talk to us today, and hope to see you at other events in the future.
Thank you.